a legal advisor to the European Commission. What I'm saying is my own personal opinion. It's not the view of, not an official view of the European Commission, as may end up being apparent. The first thing I think we've all noticed, it's confirmed also by studies as well as by a lot of the preliminary references referred to the court, and indeed what we've seen internally in the Commission, is that judges and practitioners seem to have an awful difficulties in applying even the Brussels IIa regulation. And the Commission did attempt to tackle this in its proposal by proposing more concentration of jurisdiction. The irony is, of course, that the member states that most objected to this were precisely the member states that already had a good concentration of jurisdiction. They didn't seem to understand that it would actually be to their benefit, but they saw it as an issue of competence. So we're going to be left with the problem of judges in a little court who will perhaps deal with one private international law issue in their professional life, being advised by practitioners who have experience. And there is, I think, an enormous problem of education. It's education, I suppose, within the individual member states, but also something the European institutions have to try and tackle. And as Moira said, the practice guide will be extremely important in this respect. I also wanted to draw your attention to a recent judgment by the court, which some of you may not yet have seen, because it's not, strictly speaking, a private international law judgment, but it's a judgment from last week, 19th of November 2020, in case C-454-19. It's called Criminal Proceedings Against ZW. And this concerned a provision of German criminal law, which criminalized cross-border child abductions, but did not criminalize child abductions that stayed within Germany. And a woman who was prosecuted for participating in the abduction of a child from Germany to Romania challenged this provision as being contrary to Article 21, so the citizenship provisions. Now, if you look at the judgment, the court deals with the issues up to a point in a fairly orthodox manner, decides that there is an impediment to free movement, but that basically it can be justified on the grounds of preventing child abduction. And then it comes to the issue of proportionality. Now, the German authorities had said, well, basically, they hadn't even referred to Brussels IIa. They'd just said, well, there's a big difference between an internal abduction and an external abduction, without making any distinction between third countries and EU countries. The Commission, we took a slightly more nuanced view, but we also said that the most important thing was to prevent child abduction. And looking at the statistics, we accepted that the rate of return under both the 1980 Abduction Convention and in particular under the override mechanism of Article 11.8 didn't work particularly well. And to that extent, we thought that it was perfectly reasonable for a member state to provide for severer sanctions in the case of a cross-border abduction, even within the EU. But if you look at, well, I hesitate to grace it with the title of reasoning because it isn't really reasoning. When you get to paragraphs 48 and 49 of the court's judgment dealing with this argument, it stops reading like a judgment and starts to read more like a papal bull, where the court says, you can't possibly say this. The Brussels IIa is built on mutual trust. You can't possibly deny it. You can't possibly claim it's not working very well. Full stop, end of story. So this, in a sense, I think, well, I don't agree with the reasoning. I think it closes, the court is closing its eyes to reality. But to a certain extent, I think it places an extra onus on the legislature to provide good rules, but also on the judges in the member states to try and apply them properly. So this, I think, will be the main challenge with the new regulation. With regard to the changes, again, I think we would probably all agree on what are the most important changes. The first, of course, is abolition of exequatur. I think without doubt, that's the most significant change. It takes up the new system of enforcement, now takes up nearly half the regulation. And it's again become, I think, almost a sort of article of faith that exequatur is a bad thing because it adds an extra layer, it's expensive, time consuming, and so on. Whereas at least the advantage with exequatur is that conceptually it's different from enforcement and the previous regulation. It did provide for harmonized rules on time limits in exequatur and so forth, because the abolition is based largely on the model in the Brussels I regulation, while still maintaining the reasons for refusal of exequatur. They're now displaced downstream to the stage of enforcement. But the actual details of the enforcement procedure are left very much to national law. And because national law will need to take this on board in providing for time limits and so forth for the judgment debtor to actually appeal against the enforcement. So oddly enough, under the Brussels I system, the Brussels IIa regulation came into force in 2015, but of course its provisions on abolition of exequatur only apply to judgments that were granted in proceedings abroad after the beginning of 2015. So, as far as I'm aware, there aren't actually any judgments before the Court of Justice on these provisions. I think an optimist would say the fact there hasn't been any cases suggests the system is working reasonably well, which is the message that we actually get from national ministers of justice. So I think we have to keep our fingers crossed and hope that that will work okay. On the issue of authentic instruments and agreements, as the previous speakers have said, there's now quite a detailed regime, but of course it only appears in the chapter on enforcement. It doesn't appear in the chapter on jurisdiction. The previous Article 46 was on authentic instruments and agreements, was kind of taken from the Brussels I system without much thought as to what it actually covered. And my own reading, although it was fairly idle sort of speculation, was that since it talked about enforceable, it couldn't apply to divorces, which are never enforced as such, could only apply to agreements on parental responsibility. Now, it's kind of ironic that this question all came to a head in a case which didn't even involve the Brussels IIa regulation and had nothing to do with authentic instruments or agreements, namely the Sahuni case. Here, of course, this was a case of a national court borrowing the Rome III regulation to deal with an issue of recognition of a third country divorce. and this was a unilateral Islamic repudiation registered with a Sharia court, a world away, one might think, from Brussels IIa and Rome III. And the court, of course, in the first Sahuni order said, well, this is really nothing to do with Rome III. This is inadmissible. But when the case came up a second time, there was a lot of discussion about scope. And we were slightly surprised that there was a submission from the French government, which said that neither Rome III nor Brussels IIa were limited to judgments pronounced by a court. So we thought, well, France doesn't really have an interest in Sharia law, so what's behind this? And it became obvious afterwards that this was all to be seen against the background of the French reform of divorce law, which allowed these informal divorces and which had been forced through politically, despite the fact that the Justice Ministry were well aware that this might cause considerable problems with recognition. And within the working group, there was a lot of discussion on whether Article 46 of the Brussels IIa regulation actually covered this kind of divorce, because in English, the word enforceable, also in German vollstreckbar, seemed to assume that it had to be related to content that was actually enforceable as such, whereas the Germans argued no, executoire is not so, doesn't have such a strict meaning and can cover divorces. So the opportunity was taken, but at a very late stage in the discussions, to make better provision for recognition of informal divorces and agreements on parental responsibility. And I think in principle this is a positive thing, because there's going to be a lot more dejudicialization of divorces. And as we've seen, the oddity about this is, well, I think it's twofold. First, there's the point that these agreements and authentic instruments are not subjected directly to the jurisdictional rules. However, there has to be certification that the divorce took place in a member state whose courts would have had jurisdiction under the regulation. So there's a danger of Reno divorces, I think, and having talked to a lot of French professors about this, they're also concerned that both the lawyers, the notaries, and the authorities which certify that there has been compliance with the jurisdiction rules and maybe a little bit ole ole about this. So there's a danger of, there's certainly a danger of forum shopping, with people going to member states which have liberalized divorce and getting a divorce. Now, on the divorce issue, this is probably not so important, but I think what is more striking is on the issues of agreements and authentic instruments relating to parental responsibility. If we look at the provisions of the regulation, which look at hearing of the child, making sure that all the parties have been properly informed, given the chance to defend themselves, we then see that there's much less kind of encadrement of this for agreements and authentic instruments. There is a possibility under Article 68 under Article 68.3 of refusal of recognition or enforcement when the child has not been given an opportunity to express his or her views. But if we look, for example, at the French rules, we see that the child will only be heard if, in the context of an agreement on an authentic instrument, if the child wants to be heard. So there is, I think, a danger if the parents agree and that the child simply isn't properly informed of his or her right to be heard. So although I'm in principle in favour of this new system, I think it shows signs of being done rather hastily. So I think we can anticipate some problems. Other issues with regard to child abduction, I think it actually makes sense to put child abduction in a new section. I think, and in many respects, Article 11 was too condensed. So it certainly needed expanding, and it makes some sense to put it in a new section. Because the problem is with child abduction is that in some respects it's completely separate from parental responsibility, but at the same time is based on there being breach of a right of custody. So you can't completely separate. But I think the relationship between this section and the 1980 Abduction Convention on the one hand, and the rules of jurisdiction of the regulation are now made clearer. And I think also it's a positive thing that a return decision made by the court in the state of refuge is now given the status of a decision under the Brussels and under the new regulation. So if there's a further abduction to another state, then this can be enforced directly through the decision. There is still nothing specific on whether a decision taken in the member state having jurisdiction under what is now Article 10 will be Article 9, which says that the child was wrongly taken from the state having jurisdiction, can have any kind of res judicata effect in the member state which is adjudicating on the return application under the Abduction Convention. Now, funnily enough, this was a question that was actually raised by the court itself in the OL and PQ judgment, which concerned the case of a family or a husband and wife who were habitually resident in Italy, but the mother gave birth in Greece and then refused to comply with the previous agreement to go back with the child to Italy. There, the court held, I mean, correctly, that the child could not have been abducted from Italy because she'd never been habitually resident there. But there was an issue, the fact that the father, prior to making the application in Greece under the Abduction Convention, also made an application, a parental responsibility application in Italy. And the Italian courts said, no, we don't have any jurisdiction because the child's never been habitually resident here. The Greek courts, on the other hand, if you read the reference, they clearly wanted to say that the child had been habitually resident in Italy. The court then asked the parties a whole load of questions about whether the judgment of the Italian court refusing jurisdiction on the grounds that the child was not habitually resident there had any res judicata effect, which would bind the Greek court. And indeed, the whole hearing focused on this issue. But then you see nothing whatsoever about it in the judgment, which I think is a bit of a pity. And I think if you look at the judgments on the Brussels IA regulation, in particular the Gottauer Allgemeine Versicherung case, there the court interprets res judicata very broadly and says that even a judgment of a court declining jurisdiction can actually have a res judicata effect in respect of other matters. which form part of the reasoning leading to the operative part. So I think it's a pity that the opportunity wasn't taken to provide further clarification of these aspects. Taken by and large, I think that the new regulation does provide an added value. Again, I probably should be burnt at the stake for saying this. As a good commission official, I have to say that I'm quite glad that the regulation has seen the light of day in its present incarnation, rather than in the incarnation of the Commission's proposal, which I think would have been much, much more complicated to apply. I didn't understand it myself very well, and I think it wasn't necessarily Professorenrecht, but more Beamtenrecht. So if you think that the present new Brussels IIb regulation is complicated, you should look at the proposal, and I think the regulation is much less complicated than the proposal would have been. So let's just hope that it actually does represent an improvement in practice. Okay, I think I've run out of my time, so I'll end here. Thank you.